All right, welcome back. This is presentation 2 of the federal courts. We're going to jump right in and talk a little bit about, again, some of the key aspects of the legal system and the federal courts. So jurisdiction is an important concept. Jurisdiction refers to the sphere of a court's power and authority, and generally there's a geographic element to it. Federal courts have jurisdiction over the enforcement of federal laws, treaties with other nations, or issues related to the Constitution. There are 94 district courts divided based on geography, distributed among each of the states. The circuit courts of appeals are organized into 11 regional circuits, the DC circuit, which is what we saw in the previous slide. Article 3 of the Constitution gives the Supreme Court the original jurisdiction. So the Supreme Court has both original and appellate jurisdiction. We'll talk about appellate jurisdiction in a minute. But original jurisdiction for the Supreme Court deals with 4 specific jurisdictional issues. 1, cases between the United States and one of the states. 2, cases between 2 or more states. 3, cases involving foreign ambassadors or other ministries. And 4, cases brought by one state against citizens of another state or against a foreign country. So the Constitution grants the Supreme Court appellate jurisdiction in all federal cases, and most cases adjudicated by the Supreme Court, again, appear through its appellate jurisdiction. Due process, again, is a very important concept. It relates to the idea of the just administration of the laws. Ensuring that wrongful convictions can be appealed and vacated. Defendants convicted in state courts may request what is known as a writ of habeas corpus from a federal district court under certain conditions. So, this is known as the Great Writ. The writ of habeas corpus is Latin for you have the body. And in legal terms, it's a court order that an individual that's held in custody must be brought into court and shown the cause for their detention. So the right to file a habeas corpus petition is guaranteed by the Constitution and can only be suspended in cases of rebellion or foreign invasion. Again, defendants must show that they have exhausted all available state remedies and must raise issues not previously raised in their state appeals. Federal courts of appeals and the Supreme Court have appellate authority for federal district court decisions on on habeas corpus petitions. So while the federal courts hear only a small fraction of the civil and criminal cases decided each year in the United States, federal court outcomes often set the tone for state court decisions. Federal courts, again, hear a small percentage of all the cases that are heard. In 2019, the federal district courts received 390,555 cases, which is 3% of the number of cases heard overall. Federal courts of appeals received 48,486 cases, which is 12% of all the appellate cases. Roughly 6,500 or 15% of circuit court rulings are appealed to the Supreme Court. It can range upwards anywhere from 6,000 to 9,000 in a given judicial term. As a result of the Judiciary Act of 1925, the Supreme Court has broad latitude on accepting cases. This is known as the Judge's Bill. It was a result of a study appointed by Chief Justice William Howard Taft, designed to reduce the workload of the U.S. Supreme Court. The 3 justices Taft appointed to the commission, Willis Van Devanter, that's a tough one, James Clark McReynolds, and George Sutherland worked closely with Congress. And as a result of the law of SCOTUS, the Supreme Court retained mandatory oversight on cases, which raised questions involving federal jurisdiction. The bill also created what is known as the certiorari process, and certiorari is Latin for to be more certain. Allowing the court to pick up and choose which cases to hear and which to decline. So over the course of the Rehnquist and the Roberts courts, stretching back into the 1990s, fewer than 100 cases per year have received full scrutiny by the Supreme Court, and that is by choice. Composition of federal trial, appellate, and Supreme Courts. Again, the federal courts, there are 94 district courts that originate the legal process in federal courts in the federal legal system. Congress authorized the appointment of 687 or 678 federal district judges that are distributed among those 94 districts. So most districts have more than one, some have only one, and that creates problems that we can talk about in a minute. District judges are appointed according to workload. The busiest courts in highly urbanized states may have as many as 28 judges. So like Chicago, New York City, Los Angeles. In most instances, cases are assigned to a single judge, except where statutes provide for 3-judge panels to deal with special cases. The federal appellate courts, again, about 20% of all lower court cases are reviewed by the federal appeals courts. Congress has authorized 15 or however many circuit court judges. I'll have to look that up and put that into the slide. That's like 128 or something like that. Each circuit court of appeals has 6 to 28 permanent members, and they typically sit in 3-judge panels. In some cases, particularly following an adverse judgment from a 3-judge panel, a party may seek an en banc appeal, which again would have the entire circuit sit to hear the case. And this will happen, for example, when you get 3 members that are all appointed by Republicans or Democrats, and the losing side feels like politics played a role in it. The Supreme Court, Article 3's vesting clause installs the judicial power of the United States in the Supreme Court. The Supreme Court's composition is determined by Congress. Let me see. SCOTUS is the only federal court established by the Constitution. The lower courts are created by Congress and can be restructured or abolished by Congress. The size of the Supreme Court over the course of the 19th century was 6 for a time, then 5, then 7, then 9. In 1863, the court size was expanded to 10. And then in 1869, the Circuit Judges Act set the composition of the Supreme Court at 9, and it's remained there ever since. Now, what's consequential about this, and what we need to be thoughtful about, is that there is nothing that says that it has to be 9. It could be fewer, it could be more. The one thing you would have to say, if you wanted to have fewer justices, you would have to wait for attrition to get to that number. You can't fire or impeach judges simply because you want them gone. So how judges are appointed: federal judges and justices are nominated by the president and subject to the advice and consent authority of the Senate. While there are no formal qualifications, presidents try to identify potential judges who share their partisan and ideological beliefs. In the past, administrations have tasked the White House Office of Legal Counsel to identify potential candidates for judicial nominees. While the Constitution is silent on qualifications, likely judicial nominees at minimum have typically earned a Juris Doctorate, practiced law over a period of time, and developed a reputation for legal excellence. Donald Trump, in his 4 years in office, really appears to have outsourced the recruitment process for federal judges to the Federalist Society, which is a conservative judicial interest group where Leonard Leo, a former vice president of the organization, led the effort to identify and secure the confirmation of conservative judges and justices. Democrats, there's a zero-sum nature to judicial confirmation. The use of the Senate's confirmation authority is often employed to slow down presidential nominations, particularly in instances where the president and the Senate are held by opposite parties. The Senate majority has incentives to slow down judicial nominations. By tradition, the Senate allowed district court confirmations to go through as a matter of course, and generally reserved opposition to circuit court and Supreme Court judges, and even then relatively sparingly. By the 2000s, however, the norms restraining Senate rejections of judicial nominations had broken down, and both parties increasingly used filibusters to slow down or stop nominations in order to, hope that the election of a president of their party would basically end up with a backlog of judges to fill. Democrats invoked ultimately what was known as the nuclear option to stop Republican obstruction in 2013 and allowed Obama to appoint more than 300 district court and 55 circuit court judges. And again, 300 out of 600 and something, I mean, that's close to 50%. In 2017, Republicans extended the filibuster ban on Supreme Court nominees. And again, the nuclear option was basically saying we're going to change the rules and prevent you from filibustering confirmations. And Republicans warned at the time, if you do that, we're going to do it too. And they ultimately were able to get 3 Supreme Court nominations as a result. Supreme Court appointments, again, political factors are decisive when it comes to Supreme Court appointments. Supreme Court nominations offer presidents a unique opportunity to establish a long-standing legacy likely to survive their terms of office and oftentimes their own lives. 6 of the 9 current justices of the Supreme Court were appointed by Republican presidents. Conservatives have enjoyed a majority on the court for 47 years. The exception was 14 months between the death of Associate Justice Antonin Scalia in February 2016 and the confirmation of Associate Justice Neil Gorsuch in April of 2017. For that period, a 4-4 split prevailed between the judicial conservatives and liberals. Going back to the 1980s, Supreme Court nominations have involved intense partisan struggles. Once a president nominates a prospective judge, interest groups supporting or opposed the nomination mobilize opposition in the media, the public, and apply intense pressure to key senators. Following the death again of Antonin Scalia, who I mentioned a minute ago, the refusal of the Republican-controlled Senate to hold confirmation hearings for Barack Obama's replacement nominee of Scalia, Merrick Garland, and that name should be familiar to you because he's now Joe Biden's Attorney General. That really infuriated Democrats. Senate Majority Leader Mitch McConnell's rationale was that the nomination should be made by the winner of the 2020 election. And that was belied when McConnell forced through the nomination of Amy Coney Barrett following the death of Associate Justice Ruth Bader Ginsburg just days prior to the 2020 presidential election. So these are the current justices, going from, again, Clarence Thomas has been on the court since 1991, all the way to Ketanji Brown Jackson, who was confirmed to the court in 2022. The power of the Supreme Court is judicial review. Judicial review refers to the power of the judiciary to scrutinize the actions of the legislative and executive and state governments, for that matter, to determine whether whether those actions are in accordance with the Constitution. There is some ambiguity in the nature of Article 3's vesting clause. Article 3, Section 1 states that the judicial power of the United States shall be vested in one Supreme Court and such inferior courts as Congress may from time to time ordain and establish. The judges, both of the Supreme Courts and the inferior courts, shall hold their offices during good behavior and shall at stated times receive compensation which cannot be diminished during their time of office. Some delegates assumed that the judicial power implied judicial review. Others believed that each branch of government would interpret the Constitution as it applied to that branch. That was kind of a bizarre argument. The role of the judiciary in terms of judicial review was resolved with the acceptance of the court's majority decision in Marbury versus Madison, which dealt with actions taken by the outgoing Adams administration's dramatic expansion of the federal judiciary, populating the new courts with Federalist loyalists in the closing days of the Adams administration. Some of the judicial commissions were not delivered, and that resulted in the those judges basically suing the incoming administration for those commissions. The Supreme Court ruled that the court lacked the authority to compel the administration to deliver those commissions, but they also ruled that provisions of the Judiciary Act of 1801 were unconstitutional because they violated the separation of powers. In striking down that clause of the Congressional Act, they assert judicial review, and they did so in a way that didn't directly challenge the Jefferson administration. So it's important to keep in mind the court has preserved the power of judicial review by using it sparingly, and that is kind of careful, an admonishment for judicial activists everywhere. The National Federation of Independent Businesses versus Sebelius. This is another example of sort of why the court has been able to preserve the power of judicial review. Conservative interest groups challenged the Affordable Care Act on several grounds. The implications of those legal challenges were that if they could strike it down and create, and basically invoke federalism, it was going to really make it hard for any kind of uniform healthcare policy to be enacted. Chief Justice John Roberts played a key role in crafting that compromise ruling. Conservative legal scholars and interest groups argued that Congress exceeded its authority under the Commerce Clause by imposing a mandate on Americans to purchase health insurance or pay a fine. Chief Justice Roberts upheld the constitutionality of the mandate by declaring it basically was a tax, it wasn't a fine. He also struck down a provision of the ACA that mandated significant expansion of Medicaid, imposing basically an all or nothing choice on state governments: accept expansion of Medicaid or lose Medicaid funding altogether. So again, over the course of more than 2 centuries, the court has concluded that fewer than 160 acts of Congress directly violate the Constitution. That's really the criterion point for what we would consider to be judicial activism. And again, a more activist court becomes increasingly a more controversial court. Judicial review of state actions. The power of judicial review of the Supreme Court to review the constitutionality of state legislation and other state agencies is implied under Article 6's Supremacy Clause, which we discussed in Chapter 2. The Judiciary Act of 1789 basically said Congress delegated to reverse state constitutions and laws whenever they are clearly in conflict with the U.S. Constitution, federal laws, or treaties. Article 6 further binds state judges to the Constitution, federal laws, and/or treaties. The Supreme Court frequently monitors state enforcement, and the government has developed numerous principles to ensure police conduct does not violate constitutional liberties. For example, in a 2012 decision, the Supreme Court found that police use of a GPS tracker constituted a search as defined by the Fourth Amendment and therefore required a warrant. Additionally, in Riley v. California in 2014, the court ruled that police could not undertake a warrantless search of the digital contents of a cell phone. Side by side. This is the last slide too. This is basically a comparison of different high courts and those that actually impose term limits and/or mandatory retirement ages. And if you look at it, we're one of 5 of these states that actually has life under good behavior. Many of them have term limits, some as long as 12 years. Some have a mandatory retirement age. If you look, it looks like 75 would be sort of the upper reach. Right now, that would only disqualify one of our current justices, and that would be Clarence Thomas. And then again, some have very large, the Indian Supreme Court has 28 justices. The German Constitutional Court has 18. We are, again, at the lower end. Australia only has 7. So interesting stuff there when you think about it. So that's it for this slide. When we come back, we will continue our discussion of Chapter 13, the federal courts. I'll see you next time.